Or what there's and stuff. Yeah, see, awesome. I think that's pretty, that's fun. Yeah. When I was like, same stuff, they were very across, it just all with the face to do a little more exciting things. I like these. It's a little bit, but it's like people you care about. Yeah, exactly. I mean, that's what the ground was a lot of writing. Yeah, I'm sure it'll be a touch. I'm sure a lot of you
We're ready.
Okay.
Good morning. We'll go on the record now. Time is just about 10 o'clock in the morning on the 21st of April in 2026, and this is the hearing for Deschutes County file numbers 247-25-00705-SP, 706V, 708-LM. My name is Greg Frank, and I am the hearings officer in this matter. Before we turn to the particulars of the hearing, I would like to turn things over to Planner Stewart to describe how the electronic process is going to be working today. Ms. Stewart.
Good morning. For the record, my name's Audrey Stewart. I'm an associate planner with the Deschutes County Planning Division. The item before the hearings officer is an appeal of a site plan review, 2 variances, and landscape management review for an expansion of an existing school. Today's hearing will proceed as follows. First, staff will explain the hearing format and how to testify.
Everybody here? Okay, just want to make sure.
This will be followed by a brief presentation on the application. The county has established time limits for testimony as follows: 30 minutes for the applicant, 20 minutes for the appellant, 10 minutes for public agencies, 3 minutes for the general public, and 10 minutes for the applicant's rebuttal. However, the hearings officer can modify or eliminate these time limits. When the testimony portion of the hearing begins, the applicant will present first, followed by the appellant, then any agencies, and then those in support, then those in opposition, and finally anyone neutral to the applicant's request. Afterwards, the applicant will be afforded an opportunity to present rebuttal testimony, and finally, staff can make closing comments. This is a hybrid public hearing with both in-person and remote participation. Before starting your testimony, please provide your first and last name, as well as your mailing address. For our in-person participants, if you wish to testify, please add your name to the sign-in sheet, which is right by the door over there. I'll use this list to call up participants for their testimony. After your name is called, please come up to one of the tables at the front of the room, up here, before beginning your testimony. For our remote participants, if you want to testify, you must be logged into Zoom or have called in using the Zoom dial-in option. When Hearings Officer Frank asks if anyone attending remotely would like to testify, you will need to use the raise hand feature to notify staff. To do this, you need to press the raise hand button on your computer or smart device, or if you've called in, dial *9. In addition to oral testimony, if anyone has written testimony to submit, please hand it to me. If you're in person, please hand it to me after your oral testimony. And if you're participating remotely, you can submit it to audrey.stewart@deschutes.org. Hearings Officer Frank and staff are responsible for conducting an orderly hearing. Any testimony or behavior which is inappropriate will be addressed and may result in that member of the public being removed from the hearing. Are there any objections to the format of the hearing? If you're attending remotely and have an objection, please use the raise hand function. Seeing none, I will turn it back over to Hearings Officer Frank.
Thank you, Ms. Stewart. As Ms. Stewart described, we are following the normal hearing procedures in the county code, and I will provide sufficient opportunity for everyone to participate at the appropriate time. I'd ask for your patience as we make sure we get through each of the steps she just outlined. The application is being considered through the quasi-judicial process. I will consider only the factual evidence that's in the record. I will apply those facts to any relevant provisions of the county comprehensive plan and land use regulations. The standards and applicable criteria relevant to this hearing were identified in the public notice announcing this hearing. They are also set forth in the staff report decision. The public notice and the staff report and decision are posted on the county website, and they are also available directly from staff upon request. It is important, it's really important that you direct all your testimony to relevant standards and applicable criteria in this case. If you believe that a criterion applies, and I'm just going to step back real quick. For those of you who are not familiar with land use process, okay, and not everybody comes to these and gets paid to come to these, and it's their job. So I'm just going to help out the folks that aren't in this. When I say applicable criteria, for most of us, when we're not here, applicable laws or applicable rules. Okay, so when I'm talking about, and in my prepared statement, applicable criteria, you have to be able to show me what the applicable laws, rules, or in technical terms, criteria are. So that's what I'm asking you to do. So if you believe that a criterion, rules, laws, apply that were not listed, you may address those unlisted criterion. However, I urge you so strongly to explain why you believe that criterion, that law, that rule does in fact apply in this case, so that other participants in the case may, including me, which I am a participant, may respond to your allegation that there's another rule, there's another law, or there's another criteria that in fact apply. The failure to raise an issue with enough detail to enable me or other participants to respond precludes, in other words, precludes your ability to appeal that issue to the Land Use Board of Appeals, and that can theoretically happen after me and or the commission. Also, the failure to raise a constitutional or other issue relating to any proposed conditions of approval with enough detail to allow me to respond to the issue in my decision precludes, in other words, stops, an action for damages in circuit court. As I just noted, I serve as a county hearings officer and have been assigned in this matter. In that role, my job is to be a neutral decision maker. Thus, while I have a contract with the county to serve in this role, I am obligated to remain impartial, and I do not represent the county's interests or the interests of any participant in this case. To that end, I will state for the record that I do not have any relationships with the applicant. I am not aware of any connections that I may have to any other potential participants in this proceeding that would prevent me from making an impartial decision. I have communicated with staff, but only to discuss particulars of today's hearings and not any substance of this case. In other words, staff tells me, can you have a hearing on this date? Can you be there? Can you do this? And sends me a bunch of papers, which you have access as well. So that's what staff does with me. That's my contact with staff. I have communicated with staff, but only on those bases. I do not have any ex parte. In other words, I have not talked to anyone except for staff about this case outside of this hearing. Have not done that. Don't do that. It is my obligation to preside over this hearing in an efficient manner. And I'm just going to ask Stuart, how many do we have signed up for testimony today? Do you know?
I believe it's just the appellants, and then everyone else in person and on Zoom is from the applicants.
And online, anybody?
Just some people from the applicants team are here kind of as backup for questions.
Okay, cool. The reason I ask that question is I just want to know, sometimes the hearings room is full, and sometimes there's lots of people, and they all want to testify, and I want to give everybody an opportunity to testify, and because of that, I always ask how many are going to testify. If there's lots, I put time limits on this. Today, I'm not going to put a time limit on you, but I'm going to make it your responsibility to stay to the point of this hearing. We don't get off on other tangents. We just stay to the point of this hearing because that's what we're here for. And that's your time's valuable, my time's valuable, and we want that to be done. All right. Does anyone, since we're only talking about people here, does anyone here challenge or contest my ability, my impartiality, my technical ability, if you want, to hear this case. If you wish to do that, now's the time to do that. Nobody's jumping up. I appreciate that. But people have done that in the past, so we deal with it. All right. So I'm going to continue to hear this case. I'm going to turn this back over to Ms. Stewart to deliver the staff presentation. After that, I would ask the applicant to be prepared to make their presentation. Ms. Stewart.
Thank you, Hearings Officer. I'll provide a brief overview of the subject application and the appeal. The subject property is located at 19835 2nd Street and is developed with an existing elementary school. The property is split-zoned Tumalo Residential District and Tumalo Commercial District. The applicant proposes to expand the existing building for Tumalo Community School. This includes an addition to the northwest corner of the building for a cafeteria expansion, as well as onto the southeast portion of the building for additional classroom space. The applicant also proposes to modify the vehicle parking area to the east of the school building. The application includes 2 variances, one to the length of vehicle parking stalls and one to the front yard setback. These applications were deemed complete on January 29th, and an administrative approval was issued on February 17th. An appeal was filed by a neighboring property owner to the southeast of this school. The appeal materials raise concerns about impacts to the appellant's property, which is bordered by Bruce Avenue to the west and 3rd Street to the south. As indicated in comments from the road department, right-of-way abatement is a separate process that the road department has the authority to undertake, regardless of whether there's a proposed land use action. In response to the appeal issues, staff submitted a brief memo to the record on April 14th. The full record is available on the project webpage, and I'm available for any questions from the hearings officer.
Thank you, Ms. Stewart. I have no questions at this time. This is the time and the place of the applicant. If you come up, and anybody who testifies today, I want your first, last name, I want your address, so we have that so we can send out things. But make sure you speak clearly into the microphone if you would, please.
For the record, Greg Blackmore, Blackmore Planning and Development Services, 19454 Sunshine Way in Bend, Oregon. And I have some slides to share with you
Okay.
today. Let's see. Make sure I can do this. I think I need to be elevated to a panelist.
It's not working. So I'm gonna try and pull up your.
Oftentimes I'll have to,
Yeah. Hearings Officer Frank, we're having some technical difficulties. I may have to run the PowerPoint. For the record, Anthony Regini, Principal Planner. Anthony Regini, Principal Planner. I may need to run Greg's PowerPoint from back there. So Greg, you may not have control of it. So I'll try and follow you and move you forward if I can.
should I email it to you
Or
or to?
I think Tracy's got the thumb drive back there.
No,
No.
in the past, we've always just elevated me as a.
Yeah, it's not letting us elevate.
Okay.
So if you could email it to Audrey.
Thank you, sir.
Okay.
On Zoom?
Sorry about that.
Hearings officer, is it okay if we break for a few minutes so we can
It
get this
is.
loaded without everyone waiting?
Would you like to go off the record, or would you like to just we'll go off the record. If those of you, this should not take, I don't think, very long. If you'd stay in the audience, Ms. Stewart will let me know when they're ready again, and we'll start again. Go ahead, sir. just let Ms. Are we on the record? All right, we're back on the record. Go ahead, sir.
Sorry about that. Again, Greg Blackmore, Blackmore Planning and Development Services, 19454 Sunshine Way, Bend, Oregon. And sorry for the delay. I think we'll go ahead and this presentation is relatively short, and we'll make ourselves available for questions should you or anybody else have some. So, oops. What we have here, the slide deck, that we have a full team here. So of course, myself, land use planning consultant, we have owner's representative, we have the owners actually on the call, traffic engineers here, civil engineers here, architects here, who else? Even the landscape architects here. So we have a full team available to answer any questions. A lot of time and energy has gone into this project from the get-go to make sure that it's been designed to meet all code standards. So we feel like the team here is all, of course, we've prepared detailed materials, and we'll be here to answer questions should you have any after the presentation. So what we're going to run through real quick is a quick summary of the project. We have some brief comments on the staff decision. We have some comments on our assessment of the appeal. And then, as I noted, we'll make ourselves available for questions that you might have. So let's see if you can see up here. So just, Ms. Stewart identified where the improvements are. So just to start out, this school has been the site of the Tumalo Community School since the early 1900s. It's a historic, school. It's been around for a long time. So there's some additions that are planned up in that northwest corner. In the northwest corner, mainly cafeteria and kitchen space. And then down in the southeast corner, there's an expansion that's intended to accommodate additional students. And so I believe the numbers about 210 additional students or so. So there's additional students, and historically, the site has accommodated K through 8. More recently, just due to various populations, it's been less, and it's since and the plan is to accommodate that K through 8 population moving forward as it had in the sort of throughout the past. So in addition to the structural improvements, they are just building improvements. As noted, that the parking lot on the east side of the site is planned to be improved and expanded. There's also some areas around this. The exhibit that you're looking at here is actually the fire. It's the civil plan sheet. It identifies where fire access is. So over on the east side, you can see that there's expansion to the parking lot that also provides. You can see fire access will come from the north, and then fire trucks are not able to back out that long of a distance. So a fire truck. The only reason there would be any access onto 3rd Street, which is I think somewhat relevant, is it would be fire access. It's not really regular general access. It's just fire access, and then there's some additional fire access points on the west side of the building and on the south side of the building. So yeah, mainly all access will be taken from 2nd Street to the north to that new and expanded and modified parking area on the east side of the building. As Ms. Stewart indicated, there's a number of applications that have been applied for. We have the site plan. There's an element of non-conforming use. The building, since it has been there since the 1900s, there's some non-conforming use components to the application. There's 2 variances, and also there's a landscape management review. So as we reviewed the staff report, the staff decision, findings, conditions of approval, generally concur with all of those findings. We think it's a well-written decision. It addresses all approval criteria, development standards thoroughly. Comments on the appeal. So there's a few things we're going to talk about here. One, questioning whether the appellants are a party to the record and able to file the appeal. And then above and beyond that, whether this is the appropriate venue to address their concerns. Really uncertain about what applications are being appealed, given that there are multiple applications. And above and beyond that, what standards, criteria, and or findings are being disputed. So in order for us to properly address any appeal, we need to really understand what the appeal is. So you'll see today we're intending to provide a high-level overview, answer any questions that you might have, listen to the appellant's concerns, and then do our best to respond to them as timely as possible. Not necessarily relevant to an approval criterion or the decision. I think it is important to note that timing is of the essence. There's a growing school district. There's a need for in this particular district that's actually growing, and there's a need to accommodate these new students. And there's, it's a tight timeline already. So our goal is to have this resolved as timely as possible. And I think that's part of the reason why the appeal process is written in the way that it is written, is to ensure that these decisions are timely. So, okay, so this is small, the screen's small, I apologize, but we've referenced the code section that indicates who may appeal. And it's important to understand who may appeal. As we look at number 1, there's an indication that a party may appeal. There's no definition in the Deschutes County Code as to what a party is. So we don't have a lot of direction on what a party is. But I think that if the appellants actually do have the ability to appeal, that would be because of number 1. Typically a party, in my experience, typically a party is a party to the record, meaning that the party has that somebody has participated, and therefore they become a party. So in this case, we have an appeal. The appellants did not participate. They received notice, and they did not participate. So it's questionable whether they are a party to the record. We kind of go down there through number 2. Number 2 identifies folks who did not receive notice. So if somebody didn't receive notice, they have the right to appeal per the code. Number 3. Let's see. Oh, no, sorry. Number two is, sorry, I couldn't see that far. Number two says that if a decision was made without a notice, then folks who were notified of that decision can appeal. Number three indicates that it indicates that that somebody who didn't receive, so to whom notice was not mailed, they have the right to appeal. So if you're within a particular area and you were supposed to receive, you're supposed to be mailed to, but the mailing didn't happen, then you have the right to appeal. And then number four goes on to say that other cities and a city has the right to appeal. So clearly the appellants are not number two. Clearly the appellants are not number three. If anything, they're number one. The reality is that they did receive notice. They did not participate. So it's questionable whether they are a party to the record. And actually, this doesn't say a party to the record. It just says a party. I think it's questionable whether or not they have the right to appeal. And of course, B down there indicates, it clarifies that even if somebody didn't receive a mailing, if the mailing was sent out to them, then they're treated as if the mailing was noticed. Sorry, the notice was mailed to them. So that's number one. Who has the right to appeal? Questionable whether the opponents do. And again, this is not. We understand and appreciate it in like public process and transparency. Timing is critical for this project, and ensuring that we do follow the rules so that the building, so that the decision can be rendered or finalized, so that then a building permit can be issued, so that students can be in school, the additional students can be in school in a timely manner. It's all critical to the timing of this project. So, okay. So we go ahead and we look at what the kind of the number two item about the appeal, saying, is this really the appropriate venue to address the concerns that have been raised? And it sounds to us as if the appeal is being filed because through this process, the county road department has identified some encroachments into the right-of-way and initiated a process to make those encroachments be removed voluntarily, hopefully. But that's the understanding of what the appeal is trying to address. There's a desire to not remove those encroachments. And then, of course, above and beyond that, there's the indication of what's being appealed. We need to know what's being appealed, and what's being disputed, and so that we can properly respond. So again, getting back to what we understand the appeal to be, I think that you can see, I've highlighted a couple areas. To the left of the screen, to the west side, is the Tumalo Community School. And then there's Bruce Avenue that separates Tumalo Community School from the appellant's property. And I've identified a couple areas. We understand that there's some encroachments in those red oval areas, and that's what the concern is. Has nothing to do with the site. It is important to note that, emergency access will need to go out the 3rd Street right-of-way, the roadway where some of those encroachments may either exist or have historically existed. I'm not sure what the current status of those are. Again, this is emergency access only, and the plan is to utilize an existing county right-of-way. We understand that to be what the appeal is, or the concerns are of the appellant. Again, this is an issue that exists whether or not this project moves forward. There's encroachments in a right-of-way that can and likely should be addressed through a different venue, through that enforcement or the county road department action related to removal of those items.
Before you go on, Mr. Blackmore, I'm sure I'm going to ask appellants if they testify the same question, but I have the map or your aerial up. Can you identify where the appellant's property is on this particular slide?
I believe that it's that corner lot at the corner of
Lower left corner?
so we have the corner of Bruce and 3rd Street.
Okay, and I'm making an assumption and never fair to do this, okay? I'm assuming the appellants are over here on the left. Is that the right property we're talking about? Okay, and they're nodding yes. It's just helpful for me to put in context, and I can't put this, it's problematic to put this back up when they're testifying. So I just trying to identify what the heck I'm talking about or listening to. So thank you. That's all.
The intent of putting this in here, I think a picture speaks 1,000 words, so to speak. And so I think it's important. This is what we understand the concern to be, and understand the concern. And again, there is a letter from the road department that is in the record. And I would note that the road department clearly identifies that this is this issue is separate from the planning action and the site plan approval.
Okay.
So with that really ends our presentation. As noted, we have a full team here to answer any questions that you may have, and we'd be happy to answer any of your questions.
I asked my question. I used it up. No, with that, I appreciate your testimony. Do you have anyone else on behalf of the applicant who is going to or tends to, at this point in time, testify?
Looks like everybody agrees that I covered the topics. So,
Wow.
that's it for now.
All right.
We'll, of course, listen to the appellant's concerns, and then we have the opportunity to.
You'll have the right to rebut. So, all right. Anyone else wishing to testify in support of the applicant's position that we just heard from Mr. Blackmore? Then is there anybody neutral? I love to ask that question. Nobody ever testifies, but all right, Sarah, anyone in opposition? This would be the time and the place for the appellant or appellants, one at a time. Please identify yourself, first name, last name. Do it slowly if you can, so I can spell your name correctly and we get the address correctly. I'm a terrible speller. Okay.
Robin Sappington, Sappington. I live at 64757 Cook Avenue. And I thank you all so much for being here and for putting up with us because, and Audrey and the planning department, because this was very overwhelming for us. And I think initially we misunderstood the process and just wanted to comply with what was being asked of us. But we do have a few concerns, and I thank you, Mr. Blackmore, because it was about the encroachment that
Hey, and Ms. Seppian, make sure you're talking to me because they're not going to be making this decision. I'm not trying to be sarcastic. I am assigned to make the decision, and if I don't understand it, then everything gets goofed up.
feels weird to not acknowledge.
It's weird not to be able to talk to the people you're theoretically talking to, but I'm going to ask you as a matter of efficiency that you talk directly to me. Thank you.
In regards to the encroachment, that is our main concern, to lose some of the land on the 3rd Street side, which in the paperwork, it lists it as 4th Street. And so that was kind of confusing for us. We didn't think it was included in this because it says 4th Street, but it's 3rd Street. I think it's just a typo. So that kind of delayed our reaction as well.
Okay.
But we have no problems with the expansion of the school whatsoever. I myself went to Tumalo Elementary, and the house that I live in was my grandmother's house. And prior to that, it was someone else's, and I tied my horse up in a corral that is now our chicken coop across where this is all going in. So I have no problems with the beautiful school going further. My question is, though, because of this, has there been any studies done on the well that exists on our property?
Wells?
There's a well and access to the well on our property.
Okay, I don't have the answer to that question, but if the applicant or staff and their responses wish to respond to that. So this is kind of since we're talking about a school, this is your homework assignment but staying here. And the assignment is that when the rebuttal folks come up, listen very careful, okay? Because I'm asking the staff and I'm asking applicant if you do have any response to that question. So we'll keep kind of a list of your questions and I'm hoping that they respond to them, okay?
So yeah, where the east parking, where the fire truck access is our concern because it will, with that, we lose a portion of our land that houses our pond that has been there for, I don't know how long, to be honest with you. There are, my husband and I are Native American, our sweat lodge is also in that area, so we will have to move our church. You know, it is, the trees, we understand about the trees that are around there, but there's one in particular that's on the Third Street access that's very, very old and large. And so, my family is urging me to mention that tree because that is a special tree to our family. And so I don't believe we have a huge case against this. It was just, we wanted to get our word in that like, hey, has there been studies done on the water impact? And is there another way that we can comply with the fire access so we don't have to fight losing that water access, the pond and the church? There was yeah, so basically it was about the encroachments that will be happening because of the fire access road that will go in to access this project. So I hope that we're in the right place to submit our concerns about that. Our neighbor across the way, Mr. Kelly, he, when I first went to him, he's very experienced and he says, oh, you just don't win against the county. And 15 minutes later, he called me back and said, honey, your water's there. He's like, I think you have a case with the water rights and that encroachment. And we've all complied with what has been asked to clear that Bruce Avenue and so on. And so I think we're all in agreement and everything's going well. We definitely don't want to hold up any developments in the school. It's just more so we don't want to lose our land to that fire access road.
Okay, I appreciate that very much. I'm gonna, as I indicated, I'm gonna ask the staff and or the applicant to respond. I've got two questions, one about the water and another was whether or not there's an alternative for the fire access, an alternative location. Okay. And did I rephrase it correctly?
Yeah.
Okay, thank you very much for your testimony. Anyone else to testify on behalf of appellant or as an opponent? Come on up, please.
Did not call in the spirit of my grandma Belle, but she would have been much better than I apologize.
Thank you.
Morning. My name's Kurt Lowry, last name Lowrie.
Curtis with a K or a C? Got it. And your address?
4757 Cook Avenue. Come along. And as my wife stated earlier, our main concern is with the encroachments. As near as we know, the fence line has been there well over 120 years, as well as the tree and the irrigation pond. I do have some questions on the Bruce Avenue because on the title of our land, it says that that alley has been vacated and that we own half of the vacated alley as of, I believe it was June 20th, 2002. So I do have some questions there. And when I was talking with Quinn at the road department, he stated that they did not know where those lines were and it would possibly require surveying on that alley. We have removed the items that were in our items that were encroaching in the right of way and on the gravel road. At the time those were placed there, we thought that was private property belonging to our next door neighbor. Obviously, we were in error and those things have been moved. So right now we're only talking about the fence line, the irrigation pond, and the old growth trees that would be removed on, excuse me, I believe it's what they're calling Fourth Street on here. They talk about Bruce Avenue and then Fourth Street and Wood Avenue, but I found no reference to Third Street. So it's an assumption on my part that the Fourth Street is what they're talking about as Third Street. So that I'm sorry. As you know, we're neophytes in this whole thing, and we're just trying to comply with what you guys are asking, and then also to not lose all of that land that's been there for in our use for over 100+ years for our family. And then a complete and total explanation of how the alley, Bruce Alley, is truly working. And then also my thought is, if that alley has already been vacated and the school owns that alley, why don't they just use Bruce Alley for their access for the fire department? They give up 20 feet or 30 feet of the playground, and it would cost them a lot less money. And when I was talking with the road department, they explained to me that the only reason it's going at this point going to be a gravel road for egress for the fire department is because the school did not have the funding to go ahead and have it paved and the sidewalks put in and all the utilities and those things moved, because all the water meters and everything like that are right on the corner of the fence. Oh, it doesn't show. Of Third and Cook. So all the water meters for those houses would have to be moved. I mean, I'm sorry, those were just our concerns, and we have no problem with the school going forward. It's just the roads around it.
Okay.
Thank you.
Thank you so much for your testimony. Anyone else wishing to testify in opposition or in support of the appeal? All righty, this time for the applicant to respond. I'm sorry, Ms. Stewart.
I will note, we do have our county transportation planner here to provide comments today.
Let's let the applicant do their rebuttal, and I'm going to lump the county planner with, or county transportation expert in with your response, if that's okay.
Thank you.
Okay. All right, Mr. Blackmore.
Thank you. So I jotted down some notes, and I'm going to do my best to answer questions myself, and then I'll direct them to the rest of the team
Okay.
as needed, because I don't have all of the answers, but I think the rest of the team likely does. One thing in regards to how the site was identified and listed in the staff report, and also probably the narrative itself. In general, this site extends from 2nd Street to the north, all the way down to 4th Street to the south. 3rd Street is located on the sort of, it's on the east side of the property. It kind of intersects the middle of the property, right? And so you can get the slides back up there, but if we could get the slides back up there, I would just know that. So on the north end, we have 2nd Street. On the south end of the site, we have 13. And there's also, oh, here we go. Great. Let's see what we have here. Let's see. Here. This is probably the most reasonable. So as we look at the site, 2nd Street is to the north. And then along the east side of the property, we have the parking area that exists there that will be expanded and extended. That's a drive aisle. And then to the east of that, and to the east of that is Bruce Avenue. I think it's Bruce Avenue, 2nd Street, Bruce Avenue, Bruce Avenue. And the records show that half of you kind of look to the north, you can see to the north, there's 60 feet of right of way across Second Street. It's wider there. So as you come down to the property, half of Bruce Avenue has been vacated. So half of Bruce Avenue has been vacated. And so there's 30 feet remaining of Bruce Avenue to the east of the school district's property. And then working around there, Third Street, what we see here is just the northern half of the school property. Third Street comes in from the east side and it dead ends into Bruce. So sometimes I believe that sometimes the report really considers that intersecting right of way there at Third Street. Sometimes it's referred to as Bruce Avenue, but basically Bruce Avenue is along it's 30 feet of right of way along the east side of the property, and then there's an intersection with Third Street that takes you out farther to the east. And then when you see the broader site plan all the way down, there's Fourth Street is farther down on the bottom of the property. So Fourth Street, the references to Fourth Street are way down on the south end of the property. And then there's also another intersecting, sort of partially intersecting right of way. I don't recall what it is, that comes up from the south, and it's farther over to the west. So the property is large property, and there's in rights of way sort of intersect at various locations, or either front the property or intersect at different locations. And so, yeah, so I think the area of most relevance is looking here, the east side of the property. You have 30 feet of Bruce Avenue right of way just east of the parking area, and then Third Street comes in from the east. Okay.
This is where I'm going to probably
Picture.
look to the Deschutes County
Okay.
road expert, and he's probably going to be able to give me a little additional insight. But for this point, yeah, that works.
Okay. And then we're gonna maybe if we could elevate we have our civil engineer on. Let's see if he's there. Yep. Davis is online, and he will be talking. We'll ask Davis to talk about the well on the property and whether or not it's been studied. So I would note that, from what I know, this property is within the Laidlaw Water District. So domestic water is provided through the Laidlaw Water District to the school district property. Davis, when he gets on, we'll have him talk about whether or not a well on the neighboring property has been studied in any way, shape, or form. I would note that this project is required to contain all stormwater, all drainage on site, and there is a stormwater drainage plan on site, knowing that all water or potential impacts from this site are all contained on the property. It's not directing any water to surrounding property or to surrounding rights of way. So we'll have Davis talk a bit about that. I think what's important to note, and sometimes what gets caught up is there's right of way that's 60 feet wide, and then there's improvements that ultimately occur within this right of way. And while the appellants have encroachments into the right of way, I don't know that they necessarily impact the sort of the drive width within that right of way. So something like it's hard for me to imagine that an irrigation pond was or is located within the right-of-way, that it ever would have been placed within a right-of-way. I don't know that we have any documentation of that in the record, and to date, we haven't seen that, so I haven't been able to address that. But it's hard for us to imagine that there's a irrigation pond that was constructed within a right-of-way. So there's that item. And two, large ponderosa ponds within rights-of-way. Well, drive aisles do not necessarily need to be the entire 60 feet wide. We don't have drive aisles that are 60 feet wide. So you have a drive aisle that then the surrounding trees, say a large tree, oftentimes are able to be preserved within the right of way. So to date, I don't know if there's any indication that a tree needs to be removed in order to accommodate this drive aisle, this emergency access drive aisle that is planned within the right of way. So similarly, that's the pond question. So I don't know. I haven't, we don't have documentation of exactly where the sweat lodge is, and is that constructed within the right of way? Again, this is something that falls outside. It's not relevant to any approval criteria with this development. So I can't speak to whether or not there's, the sweat lodge, if it's in the right of way, if it's actually also within the future graveled drive aisle. Joe Bestman is going to talk to, and maybe Tarek will be talking about that. But from what I recall about the planned improvements and the comment that the district didn't have funds to fully improve that, I don't know that's in the record, and I think we might find that there was some indication that there's not a need for that to actually be improved farther. So I think I may be speaking out of line here, but I'm going to let Joe and Tarek confirm that drive aisle and the adequacy of gravel for fire access in this location, as opposed to having to truly build out the road. I think that the county doesn't necessarily want a full county built road in this particular location. But I'm going to defer to Joe and Tarek on both of those topics. So irrigation pond, old growth. I think we spoke about Bruce as an alley. I think that there's a portion of Bruce that is 30 feet wide right of way, and it does provide access to those properties. But that's a 30-foot wide right of way that exists and is not going to be modified by this proposal. In terms of, I think the other was a suggestion of whether or not there could be a redesign of fire access. I suspect there's a possibility for that. I believe it adds time, cost, and energy to an otherwise constrained project. And it probably results in, less efficient overall design. And it's not desirable, particularly given that there's right of way that's right there that can serve the purpose. So I don't know there's necessarily a need to look at alternative designs, given that there's right of way that's readily available. So I think that's the bulk of the comments that I have at this point. So I'm going to say, do we know if Davis is? Well,
Yeah,
Joe's
you-
sitting right here. So Joe's going to be up next. He's going to talk traffic. If Davis is available to talk online, that would be great. Then we'll go Joe, and then we'll go to Davis, and then I'll look to the rest of my team to see if they have anything else to add while Joe
Just
and Davis
checking,
are
can
talking.
you hear me?
Oh,
Are we ready for the online?
Yes,
This is Davis with Ashley Vance. I'm just not
Let's
sure if
do
you can
that
see
first.
me.
Mr. Bestman, you're not going anywhere, so.
Just confirming everyone can hear me?
Correct. We can hear you.
Okay, we can hear you. Go ahead, first and last name, address, please.
Davis Keeney. I'm with Ashley Advanced Engineering. Address is 33 Northwest Franklin Avenue, Suite number 110. And that's in Bend, Oregon, 97703.
Go ahead, sir.
Okay. So I'll speak to the well a little bit. We do have a Laidlaw water well in a well house located on the school's property. You can see it on that previous slide. It's sort of in the southeast corner of that slide where our drive aisle wraps around it. So we intend to maintain that well and maintain the structure around it as well, along with all the utilities and water services that run from it. In terms of a well located on the private property to the east, looking at DEQ maps, I do not believe there's a water well, but I also heard irrigation pond. So I maybe have a question whether it's a water well or an irrigation pond located on the property to the east. Based on maps, there is no water well there. There is a water well nearby. Like I said, it's located on our property and it'll be maintained. And all the barriers and boundaries and separations will be maintained with it as well. Per our survey, in terms of an irrigation pond, I don't see an irrigation pond located within any of the public rights of way. But I do not know further details on that pond necessarily. But I do, based on my maps, I'm not sure there's a well located on the private property. And if there is, it doesn't appear to be registered.
Anything else, sir?
Other than that, I guess I can also speak, Greg, just very briefly about the requirements on 3rd Street. We worked with the fire marshal and the county on this. It's our best option for the emergency routing, but also it's like per the requirements of the code and fire marshal, the gravel construction is all we were required to do. So that is the direction we went, just per the requirements from the code. That is all.
Thank you, sir. I have no questions. Thank you, sir. Mr. Bestman, if you'll identify yourself for the record, please.
Yes, hearing examiner Frank. For the record, Joe Bestman, Transite Consulting, 61271 Splendor Lane, Bend, Oregon, 97702. And I'll keep my comments pretty short. First of all, on Bruce Avenue, not only does our property not use the existing Bruce Avenue 30-foot alley, but we don't touch the existing alley either. So our project is entirely within the private property. So if there's any encroachments in Bruce Avenue, that's immaterial to this application. In terms of the fire access to 3rd Street, what we need is a 20-foot wide all-weather surface so that if it's muddy, the fire trucks can still get out. Because we have more than 150 feet of distance from 2nd Street, those fire trucks have to turn around and they're not allowed to back. So I think there's a way to weave a 20-foot all-weather gravel surface in there that connects back over to Cook Avenue. And it's unfortunate that we have to go through this appeal, which doesn't seem like the right process to resolve what's probably better resolved with a discussion with the appellant and the county transportation staff directly. And if Greg didn't make it apparent, as a school, their construction season is really limited to the summer. So of course, the timeliness of this is critical. And I guess my request to the appellants would be if they could drop the appeal and work directly with the county on finding out how to get this 20-foot all-weather surface in there. That's really what it would take to solve all of our problems.
Thank you, Mr. Besson.
Thanks.
And I will certainly ask that of the appellants with no pressure attached, but I will certainly ask the appellants. But the reason I'm following this process is that I want to make sure everybody has the right to give their full presentation. We don't overlook something to interfere with either the appellant's rights or the applicant's rights. And so it may seem like we're being a little cumbersome here, but it's better to be cumbersome here than create a bigger problem down the line for everybody. Especially if the concern of the applicant is timing. So I'm trying to make sure everybody says exactly what they want to say without any restraints. So if you identify yourself, sir.
Tarek Rawlings, Senior Transportation Planner with Deschutes County. I'm representing sort of the transportation side of community development today, as well as the road department. Most of the comments I'm going to kind of just reiterate and clarify are in the record. They're from an April 9th comment from Quinn Schubert, who's a county engineer with the road department. It's speaking on the encroachment piece, the issue that's come up, and what seems like the kind of highlighted issue here on appeal. A couple things I want to just start with in terms of clarifying, reiterating things that Davis had said, as well as Mr. Bestman, just here on record. The drive aisle and the design of that emergency access, as well as the coordination with the fire marshal and what made its way into the administrative approval from the county, is not the nexus for abatement proceedings for an encroachment in a public right of way. That is a it's what Mr. Bestman said. It's a land use appeal criteria finding that was met adequately, but it's not the nexus for removal of private property or hazards or encroachments within the public right of way of Bruce Avenue or 3rd Street. So that does need to be addressed independently from this this entire land use review process. It's true that the encroachments were identified upon notice of this proposal, but it follows its own abatement proceedings under ORS. So we, as the county, there's the authority for the permitting of really anything in the public right of way, and as well as addressing any kind of hazards or encroachments. Those are primarily under ORS 374. We also have, there are specific hazard abatement definitions, criterias for encroachment proceedings under ORS 368. And that is really the emphasis of the notification letter that was sent by the road department on behalf of the encroachment. And as far as, I just want to kind of end with, saying that as far as that goes, then that's still just under ORS. It's an independent process, the encroachment, identification of the encroachment and the abatement process itself. The only other thing I'd add is that in identifying and clearly delineating where the encroachment may have lied, what I've gotten description of is basically fences and outbuildings. It sounds like potentially the outbuildings were removed already, but fences and trees and things like that were the emphasis of what was described as the encroachment in record. In response to that, the county surveyor did go stake the corners of the properties that surround Bruce Avenue and 3rd Street and clarified through that verified survey where the encroachments lie in relation to the dedicated public right of way. Bruce Avenue, as far as I've seen in coordination with the road department and any of my own record research, does have a 30-foot public right of way. There's a portion of it that does look like it was potentially vacated historically, but there's still 30 feet that are public, and that's at least one of the components of where this encroachment lies. 3rd Street on its own is very clearly a publicly dedicated 60-foot road right of way. And I would just, I would just reiterate, it's an independent process, the encroachment and abatement proceedings that are under the authority of the road department's ORS 374 permitting authority. So I'd be happy to answer any questions, but that's really all I wanted to review.
No questions. I very much appreciate your testimony. It helped a lot. Ms. Stewart, anything further?
A few comments in response to questions raised earlier regarding water. The Laidlaw Water District and Tumalo Irrigation District were sent several notices, and I didn't receive any comments back from them. But they received a notice of application, a notice of decision, and then a notice of public hearing. For the issue regarding who's able to file an appeal, our general process is to accept and log in an appeal, and then let the applicant or appellant make an argument regarding that. If the hearings officer does address it in your decision, I would also point to DCC 2220-020. Our procedures ordinance jumps around a little bit, but that provides some additional guidance. And then I submitted a memo to the record on April 14th, very similar kind of summary of the comments that Tarek Rawlings just provided.
Thank you, sir. Thank you, ma'am. All right. I don't, you get to pick, Ms. Sappington or Mr. Lowry. You can pick one of you to come up. I'm going to take a slightly unique position here and allow this because I think in the matter of timing, Mr. Blackmore has indicated timing is important. I've read staff's memo. I've listened to your testimony, and to be real honest, I think as a matter of respect from me to you, I'd rather not just close the hearing, go off and hide and do something and write something, and then you go, what the heck is he talking about? I'd rather do it face to face. So one of you can come up and talk. And please, this is Ms. Sappington, who's now at the microphone. Please take this constructively because I'm really not trying to be authoritarian or mean or whatever. But I want you to understand my opening comments were that I needed to be really clear in my mind as to what specific approval criterion, remember, and I defined that as rules or laws that you were appealing. In other words, what was the legal basis in numbers or description that you're doing? And I didn't hear anything in your testimony that identified any specific legal criterion or issue. And I just want you can come back at me in full force and say, oh, yes, I did. But I need you to tell me, clarify for me what that legal basis is that you're appealing on.
I did not state any legal basis for it. My assumption was just on the property lines and the length that they were there. And so no, I have not, we have no legal basis truly. You're saying,
All right. And
other than this process.
yeah, I understand. And like I say, you did a great job, both of you, in your testimony, and I appreciate it. It's very heartfelt. I knew it was honest and sincere. I don't think anybody in this room disagrees with that. All right. So respect greatly what you're doing. The bottom line here is that I am forced to make a decision based on rules. We're theoretically a nation of laws, and that brings us all the way down to Deschutes County. And Deschutes County is a county of laws, and there are certain processes and there are certain rules that have to be followed. And I listened to the testimony with patience on both sides. I think the things that you raised are important, but they're not important perhaps in this particular process. And so what I heard from Mr. Bessman in particular, and he was the most blunt about it, was that this process, and Mr. Rawlings as well, there is a process to deal with the encroachment issue. So I'm going to give you an opportunity to respond. From what I understand, this entire proposal is all the improvements in this proposal, each of the applications in this proposal deal with property inside the property line of the school. Would you agree with that? Okay. If that be the case, I'm sorry, but if that be the case, then I'm going to also now believe that there is another process based on the county transportation planner's testimony that needs to be undertaken no matter what. And the issues that you've raised in this particular appeal are relevant, bad choice, relevant and appropriate to bring up in that setting, okay? So what I'm going to do is simply deny your appeal. And I can't remember, Mr. Regini. I've been doing this for quite a long time, and they probably will say he's never done that before. But quite honestly, I don't see a need for me to do a long decision and a long dissertation about all the facts that have been brought up here. It seems to me the only fact I'm concerned with that you and I agree with is this proposal is within the property boundaries that are of the school, and that your appeal doesn't have any specific legal issue that you're disputing. And so I'm going to make a decision that simply this appeal is not warranted. I will likely not address Mr. Blackmore's issues in detail because I don't want to put the county under the burden that a hearings officer without having lawyers, to be real honest, on both sides really given me the full story. I'd rather not have to make that decision and put the boundary in, or the county in a position. So I'm simply going to say your appeal is denied. I'm strongly recommending, and I will ask this as the last thing I do today, a major thing. Mr. Bessman said, I think it was Mr. Bessman said, would you agree to withdraw your appeal and then simply move on to the next process? And I got Mr. Lowry nodding, but that's not official. So I'm going to ask you, would you agree to withdraw your appeal? Okay. All right. Then we're going to just leave it at that. I am going to tell you, all of you in the room right now, since I have not done this kind of process specifically, I am going to communicate with county staff as to the appropriate how I write this up. Okay, that's the simplest way to do it. So that it's consistent with county processes, not that I agree or disagree on the substance, it's just the processes. So I'm letting you know that I will probably have an additional conversation with Ms. Stewart to confirm that the way I'm going to approach it, what document and what it says in that document meet county standards. Ms. Stewart, is that okay with you?
Thanks, Hearings Officer.
Okay, is that okay with you, Ms. Sappington? All right. I appreciate y'all coming. I appreciate all your testimony today. I tend to be some people say I talk too much, actually, but I tend to be very conversational. And I found in history of doing my law practice and doing this, that if people talk to each other, we can tend to a lot of times come to a resolution. So what I'm suggesting to Mr. Lowry and Ms. Sappington is don't waste the opportunity today. You got the whole friggin' team here. Don't waste, they won't close the room on you. Nope, they're not going to close the room on you. Take whatever time's necessary. I'm telling the applicant, take the time necessary to be a respectful neighbor and see what you can do to work this out so there's a process that makes everybody happy. Okay? So, anything further from staff?
No other comments.
Anything further from the appellant? Anything further from the applicant? All right, we're done. Thank you. We'll close the hearing.
Thank you,
Yeah.
everybody.
Thank you. Appreciate
Yeah.
your comments and